3, 2, 1.
It's an episode of Scott Talks Law, and welcome once again to another episode of Scott Talks Law. So in this episode, we shall be talking about partnership. So we shall be defining partnership and partners. We shall be looking at the types of partnership that is classified based on duration and liability. Under duration, we have temporal and permanent partnership, and under liability, we have general partnership and limited liability partnership. We shall also look at the applicable laws on partnership, which are the Partnership Act number 16 of 2012 and the Limited Liabilities Act of 2011. So we shall also look at partnership agreement, the content of partnership agreement, and we shall look at the capacity of partners, where we shall look at the capacity of minors and the capacity of persons of unsound mind. So partnership is defined from Section 2 of the Partnerships Act as a relationship that subsists among persons who carry out a business in common with an aim of making profit. So according to the Section 2 of the Partnerships Act, there are three elements that are brought out from the definition. So the business, the carrying on of that business in common, and the view or intention of making profit. So those elements must be brought out when you are defining partnership. So the first element of a business, the business must exist, and this business must be legal in nature. It excludes any unlawful activity or any illegal activity that brings people together with the purpose of making profit. So this business must be continuous in nature. Any venture that just brings people together that is not continuous in nature is not a partnership, because a partnership must be continuous in nature, and any joint ownership of property is not a partnership. So the first schedule of the Partnerships Act brings out those circumstances that do not constitute a partnership. The joint ownership of property or sharing some interest or profit is not a partnership. The receipt of debt by way of installment on some share of profit is not a partnership. The receipt of money by a servant by way of remuneration on some share of profit is not a partnership. The receipt of some money by widow or child of a deceased yearly is not a partnership. The receipt by a vendor some portion of profit of goodwill of the business is not a partnership, and the receipt of some loans of interest or interest of loans does not constitute a partnership. So the provision of the first schedule of the Partnerships Act brings out those instances that by themselves do not constitute a partnership. So this business must be carried out in common. The partnership agreement is that agreement that is created by partnership who come up to create a partnership agreement. So carrying out that business in common is approved by that partnership agreement, which sets out the rights and duties of partners. So this partnership agreement is not governed by law, but it's governed by the requirements of those partners. So there are those partners who come up with this agreement, which is not dictated by the law. So the third element is the element of making profit. So the main aim, objective of coming up with partnerships is to earn and share profit. So the main purpose is share profit, which is shared according to the predetermined ratio of partners. So these partners share losses and profit according to the predetermined ratio. If there's no particular ratio, it can be shared equally. So it can be shared according to the predetermined ratio of the contribution of capital. So it can be shared equally if there's no that ratio. So the Partnerships Act does not define who a partner is, but according to under his principle of partnership, a partner is someone who enters into partnership relationship, or someone who is in the relations of partners. So under types of partnership, we have it is classified based on duration and liability, and after duration we have temporal and permanent partnership. So temporal partnership are those partnerships that exist for a specified period of time. So the expiry date is known at the time when this partnership is formed, or at the time of the venture. So the expiry date can also be known at the end of the formation of that partnership. So permanent partnership is that partnership where the expiry date is not known at the time of formation, and it's upon the parties. The parties are the ones who determine when to end this partnership, because a partner can decide to end that partnership agreement by giving notice. So one partner can decide to end that partnership agreement by either giving notice to terminate or end that partnership agreement. Classification of partnership by liability is where we have general partnership and limited liability partnership. So general partnership are partnership that have limited liability. So the partnership is not a separate legal entity from the partners. So it's not a body corporate. The partners are liable for the debts and obligations of the partnership, and they can be sued. And when they are sued, they can be sued in the name of the firm. And when they are sued, they appear in court as persons. So the firm, it's not a separate legal entity. So they can be sued and sue the partners, and when they are sued, they appear as persons. So the partners have the right to participate in the day-to-day activity of the firm, but it's not an entitlement. It's just their right that they should participate. They can choose to participate or not to participate. So under limited liability partnership is the form of partnership that has limited liability. The partnership is a separate legal entity from the partners. The partners are not liable for the debts and obligations of that particular partnership, but they are liable for their own individual wrongful acts and omissions against that partnership. So this form of partnership has got perpetual succession, because where the death of one partner does not affect the entire partnership, because the entire partnership would remain to exist even if one partner dies. So we also have the partnership agreement and the content of partnership agreement. So the partnership agreement must conform with the provisions of the Partnerships Act, and the content of the partnership agreement must bring out the name of that partnership, the nature of that partnership, the area of location of that partnership, the duration of that partnership, how profit is to be shared among partners, a clause on banking accounts of that partnership and accounts of that partnership, a clause on that restricts a retiring partner from carrying on a competitive business with that partnership, a clause on dispute resolution management. So those are the provisions that are brought out of the content of partnership agreement. So capacity of partners, we have capacity of minors and the persons of unsound mind. So a minor is someone who is under the age of 18, who has not attained the age of majority. So a minor is liable for the debts and obligations of a partnership when he has entered into a partnership agreement. So a minor is liable unless he repudiates that partnership agreement when he attains the age of majority. So if this is a partnership between a minor and someone of a majority age, the minor will not be liable for the debts and obligations of the firm, but someone who has the majority age is the one who will be liable, or the firm if it is the name is attached to the firm, or if it is a limited liability entity or a partnership. So persons of unsound mind are liable for the debts and obligations of partnership and can be sued. Even if they are able to prove their insanity, they are still liable. So the only situation where the persons of unsound mind can escape liability is when they are able to show that they were not aware when they are entering into that partnership agreement. Someone who made them enter into that agreement knew their state of insanity, and yet he proceeded to make them enter into that agreement. So another thing about limited liability partnership, you need to know that this is a partnership that is formed to carry out professional services, and it's a partnership that is formed by firms such as the firms of lawyers, surveyors, architects, and other professionals in those fields. So that is the end, and just stay tuned for more episodes are coming on business association and other content and other episodes. Just stay tuned, subscribe to Coast Legal channel, and have a nice day.